police have a right, constitutional right, to use whatever means possible to make sure the lives of Kenyans are protected, their property is protected, and they need to take steps to make sure that if life and property is in danger, the police must act accordingly. Tumeelewana, my friends? Ati anasema ati siku iko protest ama hii vitu vita ati polisi wakae sijui wafanye nini. Wakuja wapigie watu makofi wakivunja mali ya watu. Na tuheshimu nchi ya Kenya. Sisi ni watu ambao tunafuata katiba. Tunafuata katiba. Na katiba inasema iko haki ya kila Mkenya. Hata nimeona ati leo ati kuna mtu kotini amesema ati Inspector General ya police asiweke roadblock, ati asitumie tear gas, asitumie water cannon kuprotect mali na maisha ya Wakenya wengine. Na huyo mwenye anasema hiyo, kwake kuna askari wanamchunga, kwa gari yake iko askari anamuendesha, alafu anasema mali ya wananchi wengine haina maana, polisi wasichunge mali ya wananchi wengine. Honestly, how can anybody say that the police cannot protect the lives and properties of other Kenyans? There is a reason why there is a roadblock. There is a reason why police have tear gas. There is a reason why water cannons are there. They are supposed to be used to protect the lives and property of other Kenyans when they are in danger. So a person who already has security in his house, guarded by the police, in his car, driven by the police, is telling us the property of other Kenyans is not worth being protected by the police. Haitafanyika tena. Enough is enough. Kama mtu wako na mpango anatafuta. Haiwezekani.
Na tumekubaliana the health of the coalition is paramount as opposed to the individual constituent parties that form that coalition of Kenya Kwanza. because that coalition is the government. When the government is healthy, we are all healthy. When the government is ailing, we are all ailing.
Your Excellency, kwanza nataka nikushukuru kukutupatia nafasi kama hii ya leo sisi jamii ya Mandera ili tuweze kujadiliana na tuzungumzie vile tunaweza kuendesha nchi yetu isonge mbele. Ukiwa kiongozi utalaumiwa. Wakati wengi wanasema kwamba umefanya kazi nzuri, wengine watasema uja. So wewe jukumu yako ni 50+ million Kenyans. Hiyo ndio, na tunajua wewe ni mchapakazi, endelea na kazi yako, sisi tuko na wewe.
You can say there's nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That you are grabbed from the court registry to defeat the orders of the court setting them free on board. In the case of Bennett versus the Hospital Roads Magistrates Court, the issue was precisely that if you ought to have brought Bennett from South Africa pursuant to an extradition order, and that order was not there, the court actually said we cannot allow people to be tried in English courts, people who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court, and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede. If these two accused persons had committed terrorism act in Mandera, and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts. That the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether the DPP and the police justified the derogation of fundamental rights. Those magistrates say there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Hospital versus Magistrate and in the Gedongori case, because it was the same case, abuse of power. Abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Roiro, where I was there myself. They said, we are holding these people on the basis of specified offenses. Mr. Maura Kapata had read you. Robbery with violence, arson, all these kinds of things that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is, what are the offenses against this man and woman? The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism act, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, oh, we are seeking judicial review of the decision to charge that has been made by the DPP. There is no doubt that the DPP can make decisions to charge. But you must be satisfied that you have jurisdiction. Jurisdiction can be Europe, where Deborah Giro was killed. It clearly cannot, you cannot say that you have a valid charge. Let us wait for the DPP and the police to give us evidence. You know, this is a mischief rule. The court must go to the mischief rule. The last 2 points of the Constitution is this. About your authority, that 1 and 4 of the Constitution. Under 21 and 4 of the Constitution, it deals with the issue of application of the Bill of Rights. 21 says the Bill of Rights apply to all and binds all state organs and all persons. Your Honor, you are a state officer. And you are required to observe it. But more importantly, 20 sub-article 4 is very clear. In interpreting the Bill of Rights, a court, a tribunal, or other And finally, Article 23 of the Constitution. Article 23 of the Constitution Parliament shall enact legislations to give original jurisdiction in appropriate cases to subordinate courts to hear and determine applications for redress of a denial, violation, or a threat to a fundamental rights in the Bill. Is exercised directly. It doesn't require any law. So you apply that authority as you understand it. So we are perfectly entitled to say across the world, not just in Kenya, a person who are hated, who are...
Your Honor, we have to bring this to its useful conclusion. We thank you for your patience. very briefly, in summation, Section 2 of the Prevention of Terrorism Act, number 30, 2022, and the proviso thereof. We've been addressed extensively on this, and is exercising their rights under Article 37 cannot be charged under the Prevention of Terrorism Act. The only thing in that proviso is if that is proven, then citizens are not covered under that proviso. But our submission is there's no such intention. Therefore, is actually very clear. It is actually unassailable, and we urge you inappropriate. And for the avoidance of doubt, Your Honor, the Judicial Service Commission issued a very doubt. By the way, the chairperson of the Judicial Service Commission is the Chief Justice.
You're not perhaps with your permission.
I do not expect that all the time
It's
trying
okay,
to do
but
these things.
that was not an issue that we did a rejoinder in. There was no statement that we went through. So this is a new issue that...
It's not a new issue, it's been referred to.
We need your ruling.
It's not a new
Your
issue.
Honor, with your kind permission and with the permission of Alex,
Can I be addressed by the two so that we can quickly do it?
if I can help refresh your memory, Your Honor. I raised the objection.
My memory is quite fresh.
Yes.
No, I'm saying the reading. He's now going to the reading.
No, just the same. The issue is not changed. The issue is just for the avoidance of doubt.
No, he's reading, Your Honor. Is it necessary?
The chairperson of the Judicial Service Commission, and we are officers of court, is the Chief Justice herself. And this statement the rearrest of an accused person within the precinct of the Ruto Law Courts on Friday, 4th July 2025. The facts indicate that the accused had been released. Suspects use of fire and dignity of the judiciary. Courts are sacred spaces of constitutional adjudication. Your Honor, argument about the impropriety of the rearrest. I personally like to call it simply abduction, and therefore, Your Honor, you historic because if you decide that the two accused persons, I mean, they were yet to take a plea because you object to that. In fact, we are calling on Your Honor to discharge them unconditionally, as happened in the case of Rose and Jerry just the other day. So Henry to argue that, the charges have been preferred, the ODPP has done this, and I appeared in court along with Chief Justice Emeritus, because what Rose and Jerry did was just to accept, to give our opinion with regard to public participation matters that the committee in Parliament dealing with finance had put out to the public. And then she was apprehended, actually abducted. Rose and Jerry today is a free citizen. We want to urge you to use the authority of this court so that you will enter the annals of history as one judicial officer who chose to stand for the constitution of this country. And various aspects have been addressed. Article 20 of the Constitution, for example, which binds all state actors to observe the Bill of Rights, International Bill of Rights, which is part of our domestic law now.
It's a quick question, Counsel.
Yes.
If I were to make my decision in order to enter the annals of history,
Yes.
would that be making a decision for personal interest?
No, indeed not. Indeed not. You will. I'll guide you on that one. It is simply that you apply your mind to the conversation that has appeared before you, that has been proffered before you, and to be able to apply the law judiciously, because that is what we're asking you to do. But in so doing, you will also be capturing the moment in our country's history. Right now, judicial notice should be taken of the fact that we are a country at a crossroads. And all of us have to do something to save it. We are simply saying we object to the practice of the Director of Public Prosecutions arresting Kenyans, bringing them to this court, and charge them under the Terrorism Act. That is intimidation of a sort that cannot be tolerated. In fact, it is inflaming of the country. Your Honor, I want to say that these two persons, they're actually not necessarily leaders, counsel, but they are officials of the Democracy for Citizens Party. And the very fact that the whole country is witnessing a situation where two young officials of a party are charged with an attempt is being made to charge them under the Terrorism Act. It's actually inflaming the country. You see some of us, Your Honor, appearing before you with great humility. They're sending a message. They're sending a message that somebody has to do something to ensure that this remains a country under the rule of law. This is not going to be a country where political actors, finding that they are losing ground, decide